Good morning, everyone, and welcome to this meeting of Winchester City Council's Planning Committee, taking place in the Walton Suite at Winchester Guildhall. It's Wednesday, the 12th of June, 2024, and the time is 9:30 a.m. My name is Councillor Jane Rutter, and I'm Chair of the Planning Committee. To my right sits my Vice Chair, Councillor Jonathan Williams. Around the table, we have the other elected members of the committee, and we are supported today by a number of officers: Lorna Hutchings from the planning team, Daniel Lucas, our legal advisor, the case officer, which will change generally with each item, and Claire Buchanan from Democratic Services, who supports the committee and operates the recording equipment. This meeting is being live streamed and recorded to the Council's YouTube channel. Subtitles are available, and advice on how to turn these on is set out on our website. Please can I remind everyone to ensure your mobile phones and any other electronic devices are on silent or preferably turned off entirely. In the unlikely event that it is necessary to evacuate the building, the fire alarm will sound. Please follow all the instructions given to you by our team. Please look at the handout provided on your chairs or on the information slides displayed as you walked in and during the breaks for further guidance about this meeting. To ensure the smooth running of the meeting, I ask that nobody calls out from the back of the room during the proceedings. In accordance with the public speaking protocols of the meeting, those who have registered to speak will be able to address the meeting for their allotted time. If there is any disruption of the proceedings and the committee is not respected, it may be necessary to temporarily adjourn the meeting. Finally, can I welcome the members of the public to the meeting? Those of you who have registered to speak, I will call you forward when it is your turn to make your contribution. Members of the committee may ask you questions of clarification, so please remain at the microphone until after members' questions. The microphone is turned on by pressing the button on the base of the unit, and a timer will appear on the screen to remind you of your remaining time. Turning now to the agenda. Do we have any apologies and deputy members, Claire?
Thank you, Chair. No apologies for absence received. All members are present. Thank you.
Do we have any disclosures of interest, members? Councillor Small, your microphone is on. Could you switch it off, please? Thank you. Don't know how that happened. Good, thank you. The minutes of the previous meeting have been circulated. Are they an accurate record of the meeting? Is that agreed? Agreed. And we need to accept the addendum sheet onto the agenda. Is that agreed? The update sheet. Thank you very much. So now we turn to our first planning application, agenda item 6, which is Arnwood House, Boys Lane, Colden Common. Just get that one up. There we are. And our presenting officer is Liz Young. So over to you, Liz. Thank you.
Thank you, Chair. So this application relates
Liz,
to...
Can you just point your microphone a bit?
Sorry.
That's better. Thank you.
So this application relates to a proposal for a new custom and self-build dwelling on land off Boys Lane in Colden Common. The plans also include proposals to install a replacement package treatment plant to serve both the existing and proposed house and to carry out various landscaping works. So this first slide just shows the location plan for the site, which is identified by the red line. So the site lies to the east of Arnwood House, which is, and where it shares the access with this property off Boys Lane, which is an unadopted road. It's also not a through road and is subject to a 15-mile-per-hour speed limit. The western part of the site, so that's this area here, includes part of the land within the garden area of Arnwood House at the moment. The eastern section is currently in grazing use. The blue line indicates the wider area of land which falls within the same ownership as the application site. So just moving on to the next slide, this slide shows an aerial view of the site, which is marked by the yellow star. The site lies in open countryside just outside the settlement boundary of Coldham Common, which is identified by the purple line. The site is not close to any public rights of way. It's set back from the road. As you can see, there's a line of mature trees along the north boundary. These are all to be retained. The various structures you can see immediately south of the trees include the existing access track, some outbuildings, a stable, and the large rectangle you can see there is a riding arena. So this next slide shows the proposed site layout with the proposed dwelling in the dark grey shading. This plan also shows the location of the packaged treatment plant in the corner just over here, and also the proposed planting arrangements. So the proposed access drive would replace the existing access track, which currently runs through the site. The existing outbuildings and stabling are proposed to be removed, and the riding arena, which is over in this corner, would be replaced with some new planting. The overall footprint of the building, including the proposed garage, would be approximately 400 square metres. So this next slide shows the proposed floor plan. It would be a single-storey dwelling of 4 bedrooms with a triple garage. You can also see in this plan the proposed outdoor terrace, which would be stepped down to the rear garden area, and a raised planted area would wrap around. This next slide shows the proposed roof plan. So this shows the proposed solar array, which would be mounted to the roof of the garage. The rest of the roof would be zinc. This next slide shows the proposed northwest and southwest elevation. So the bottom image is the view you'd see if you stand to the south, looking towards the rear elevation of the property. The top image is the view you'd see as you approach the site along the access drive, coming towards the entrance to the property. Along with the zinc, the roofing, the facing materials would consist of a combination of timber cladding, flint, and facing brickwork. Due to the changing ground levels, the southern projection and the terrace would be built up slightly, although overall height would be approximately 5 metres. This next slide shows the proposed southeast and northeast elevations. So top image is the view which would face east onto the grazing lands, and the bottom image is the elevation which would face north towards the north boundary of the site. Just moving on to the photos, this first image shows the view through the access to the site, which is shared with Arnwood House, the property you can see to the right hand side. No changes are proposed to the access. This next view just shows a view as you approach the site along the existing access track. So the proposed house would be located basically beyond the outbuilding you can see and slightly off to the right of this. This shows a closer view of the outbuilding which is to be removed. So the proposed new drive would pass over the footprint of this building and would then have right into the new parking area. So this just shows a view of the existing stable, which is to be demolished, and the riding arena to the right hand side, which is to be removed. The hard surfacing you can see in the foreground would be replaced with the existing, with the proposed access drive. Sorry. This next slide shows a view from within the existing riding arena. So the plan showed that this would be replaced with a combination of grass and woodland planting. This is just looking back towards the west, so looking towards the outbuildings to be removed, and you can see Arnwood House further off in the distance. This shows a view from the exact access track into the site, so the approximate location of the proposed house. And this just shows another view into the site, but looking west again, back towards Arnwood House. And this final slide shows the view looking southwards along the east boundary of the site. That brings us to the end of the slides. Just to conclude, it's acknowledged that the site lies in an outside the settlement boundary of Coldham Common in an area where new dwellings are not normally permitted. However, in this case, it's considered there's exceptional reasons which justify granting permission. Specifically, it's the contribution the proposal would make towards the supply of self-built dwellings in Winchester, also enabling Winchester to fulfil its duties under the Housing and Planning Act. This is a legitimate proposal for a self-build dwelling. The applicant is on the register and also meets the local connection criteria. It's also considered the site itself is well related to the settlement of Coldham Common, approximately 80 metres from the access, and is considered sustainable for the purposes of the NPPF. So for these reasons, it's recommended that permission is granted, subject to the conditions set out in the report. And that concludes the presentation. Thank you.
Thank you very much. We now move to public speaking. There is no objector, and unfortunately the parish council, which does have an objection, which you can see on page 19 of your agendas, is unable to attend, sends his apologies, but I would refer you to their objection at this point. So we now move to the supporter, who is Adam Clark, the agent. If you'd like to come forward, Adam, thank you. You will have 3 minutes, and the time will start when you start speaking, so settle down, you have plenty of time. Thank you very much.
Good morning. My name is Adam Clark. I am from Adam Nib Architects, and I'm the architect for this proposal. It is the applicant's ambition to create a new home for themselves, which is of high quality, contemporary design, sustainable and suited to its context. The building is low-lying and unobtrusive in the landscape, and extensive consideration has been given to its design to achieve this. The site is located outside of the Coldham Common settlement policy boundary, but very close to it, and as you've heard, the planning department has determined that the principle of development is acceptable despite being outside of the boundary, the provision of a self-built dwelling is a material consideration which justifies the proposal. Self-built development makes an important contribution to our built environment. It provides creativity and individuality of architecture, and there is a shortage of such sites in the district. The site is located within walking distance of bus stops and local amenities, making this a sustainable location for development. We note an objection has been lodged by the parish council, and we also wished to address their concerns. The first objection is that the proposal is contrary to the local plan policy MTRA4. This has been addressed by the self-build consideration. The objection also referenced comments by Southern Water identifying that a possible public sewer may be crossing the site. We would like to reassure the committee that the building regulations process would be followed fully in the event that this application is approved, which requires statutory consultation with the water authority prior to any works being undertaken. If a sewer is found to be crossing the site, appropriate measures would be taken to divert the sewer, which would be very straightforward to achieve due to the very large site area. Southern Water do not identify this as a reason the application should be refused. This is a matter of process which should not prohibit planning permission being granted. The final point the parish council raises is the additional pressure on the sewage system of Coldham Common. Neither the existing or proposed dwellings on this site are to be connected to mains drainage. This proposal will therefore have no influence on the drainage system of Coldham Common. In conclusion, we submit that this proposal provides a high quality self-built dwelling which will make a positive contribution to its locality. The application has received the support of the planning department and there have been no neighbour objections. Thank you for your time this morning, and we hope the committee can support this application.
Thank you very much. Members, do we have any questions or clarification for the agent? Councillor Cunningham.
Thank you, Chair. Mr. Clark, thank you for your presentation. Could you tell me What level of input into the design and layout of the dwelling Mr. Massey and Dr. McGill had, please?
Sure, they are our clients. They've appointed us directly. We have developed the scheme entirely for them as a bespoke dwelling from the beginning. That it's entirely designed for them.
What experience do they have in terms of the design and input for the dwelling?
So that they haven't got design experience. They've employed us to design the dwelling for them. They're homeowners. They don't have any background in design or architecture. We've been instructed to design the building for them.
Okay, thank you very much. Thank you.
Any further questions, members? Okay, thank you very much indeed for your time. Thank you. Right, we come back to, do you want to add anything before we come to questions, please?
Thank you. No, I don't. Thanks.
Right, questions to our officer. We'll take questions on the whole report. I just wanted to ask, you mentioned it was 4 bedrooms. I think there are 5 bedrooms on the plan. It's a bit of a grand design, isn't it? I mean, it's massive. Five
Apologies for that.
bedrooms, one layer. I mean, it's a beautiful home, but it's 5 bedrooms, yes. Okay, and suitable amounts of parking and all the rest of it. Okay. I am concerned that that we tie down this this self-build element. We have a shortage of self-build plots available in Winchester, is that right? We have a certain number. And how do people get on this register? And how do we, you know, is it anybody who wants to be on the register? Is there some sort of criteria by which? I know there's a certain amount in the report, but if you could just embellish that a little for me.
Yeah, certainly. So there's the national requirements. So those are listed out. So I can explain what those are. So all the requirements listed for the national eligibility criteria basically say that the individual should be 18 years or over, should be a British citizen, should satisfy any local criteria set by the authority. They need to have paid a fee required by the relevant authority to enter and remain on the register. And also it's a requirement that by seeking to acquire a service plot within the local authority area for their own self-build and custom house building projects. So that's part and parcel of the criteria. Winchester has set up its own register, as that is a statutory requirement. It's a 2-part register. So those on part 1 also need to meet the local connection criteria. So the first of those is, which is what the applicant meets, is the residency criteria, which is basically a requirement that they need to live within the Winchester district. On top of those, there's people with family connections, people serving in the armed forces, and those with an employment connection. But in this case, the applicant is on the Part 1 register and meets the local connection criteria.
And what is there to stop, for instance, if we gave planning permission, that the owners therefore of the land just to sell on the plot with the planning permission to somebody who isn't a self-builder, just as a new house in the countryside? It's extremely desirable position. We wouldn't normally, given MTRA 4, consider giving planning permission to a house in this without a strong rural, you know, agricultural whatever reason. We wouldn't normally give planning permission in these circumstances, would we? So how can we ensure that it is a self-build and it remains a self-build?
So the condition set out in the report requires that the occupant does need to be, that basically requires that the proposal should meet the definition of custom and self-build. So in order to meet the definition, the initial occupant needs to have had primary input into the design and layout of the development. So, I mean, there might be an opportunity, which we were discussing, to beef up the condition and add additional requirements. For example, before occupation, we then require confirmation that the person then occupying a building is listed on the local register. So there might be scope to add additional requirements into that condition.
I think I might be more confident if we could do that. Members, do we agree that we should beef up the requirement? Councillor Lehman, you have a question.
This point actually does worry me and gives me great concern, because we've had instances before. I can think of one in my ward where it was declared as a self-build and the owner never moved in till certain significant time after, and he'd been renting it out for a year or two before he even got round to that. So we need to be cast iron on that.
Yeah, if we could ask Daniel just to go through what we might include in a new condition, then we'll come to your question. Thanks.
So yeah, thank you, Chair, through you. So the original conditions on page 3, condition 3, sorry, page 29, the approved dwelling shall be marketed, delivered and occupied as a custom built plot as defined in the legislation. And the reasons given there to obviously ensure that it meets the identified shortfall. In that regard, you can probably add more to that condition. Liz has touched upon it. So we could have, for example, the first occupation of each unit in the development hereby permitted shall be by a person or persons who had a primary input into the design and layout of the unit and who intends to live in the unit for at least 3 years. And you've heard from the architect in his submissions about the input his client has had in the design. So this should be probably uncontroversial for their client. So first occupation of each unit in the development hereby permitted shall be by a person or persons who had a primary input into the design and layout of the unit and who intends to live in the unit for at least 3 years. And then secondly, the council shall be notified of the persons who intend to take up first occupation of the unit in the development hereby permitted at least 2 months prior to first occupation. That way you ensure that the individual who's instructed the architect remains the individual. And secondly, you'll have notice 2 months prior to occupation that that individual remains the same occupier once the scheme is actually built out. If, however, we are in a situation where the permission is banked and the developer wishes to sell the site with the grant and benefit of the permission, this condition will engage or prohibit the purchaser from occupying, because obviously they would not have had primary input into the design and layout. So you will retain control. That new purchaser, that new proposed occupier would have to ask for relief of that condition by again having some input into the design and layout, and that they are indeed also a self-builder. So it works both ways, both prospectively for the client and or if the permission is actually banked and sold to a new purchaser and new self-builder.
Okay, just a minute, Councillor Lehman. I think Councillor Langford-Smith was waiting to ask a question.
Thank you, Chair. To a certain extent, Mr. Lucas has answered my question. I was going to ask, is it possible to put a minimum occupancy period in the conditions before it could be sold? But my second question is about primary input. What is the definition of primary input? Can I say about the colour of the roof tiles, or is it more than 50% of the building has to have been designed by the person that's actually going to occupy the property?
I think commissioning an architect and instructing them what you want is basically, I think that fulfills that requirement. I do, but I don't know if there's anything in particular in law that.
Yeah, bear with me, Chair. I'll have to go through the Act and actually find out the definition of a self-builder. So I'll probably deal with it in about 2 minutes.
We'll give our legal advice some time. Councillor Lehman.
I've got another legal question, so I'll wait a few moments and give Dan time.
Any other questions that won't require Dan to find something out? Thank you, Councillor Clear.
Not really a question, but the homeowner then would tend to actually have control, am I right, over the build, but work with the architect and the design people. I mean, he's not going out, is he, obviously, and building it all on his own, but he's there, isn't he? And he would have control over the build all the way through. I'm just a bit concerned about this one, I'll be honest with you.
Well, it's like, for example, Councillor, most so Barratt Homes and so on, Taylor Wimpey, they may subcontract to bricklayers. So in this instance, the architect has designed and conceived the scheme, but it may not necessarily be that that architect practice is a turnkey practice. That is to say that they have clerk of works and their own builders. I don't know about the architect's practice. So it may not necessarily be turnkey in the sense that it's all under one roof. It may be, in this instance, the architect will have to deliver to ground workers, bricklayers, and so on and so forth, much like your commercial builders would have to do as well. So there's nothing in that sense which is in any different in the South Build context vis-a-vis a commercial builder in this sense.
Councillor Laming.
As we say, this is a self-build and it's on the register. How do they get the land on the register, or is it just because they've decided that they want to do a self-build somewhere? Because this is a fundamental issue, I think.
So the requirement is that it has to be a serviced plot. So that's what the Act sets out. So I guess the two requirements are, one is the individual should be on the register, and secondly that it has to relate to a serviced plot. So a serviced plot being a plot that has or is capable of having water, electricity, foul sewage and access to the highway, which in this case the plot does have those things.
So how long do they have to be on the register before they can apply for a site?
There's not a sort of set period in terms of it. It's just a case of whether they are on the register or not. And in this case, they are on the register.
Councillor White.
Yes, just regarding the language in the report about how much notice we should take of this register of self-builds. It says they are likely to be a material consideration. So does that mean we definitely, is that a definite material consideration or up to us?
It's a legal point, Councillor, so bear with me because I'm trawling through Councillor Langford Smith's definitions of a self-build and self-builder. But essentially the duty in law, if I actually read the duty out, and then you can probably turn your mind to that duty. So there's two duties. The first is a duty to keep a register. So you have to, as a matter of law, keep registers. That's central government, that's the dictate of Parliament, that's what we're doing, we're keeping registers. The second duty is the duty to grant planning permission. So in the report, you're seeing the officer reconcile our local plan policy against the statutory framework here. So the statutory framework says an authority to which this section applies must, so you have to here, must give development permission for the carrying out of self-build and custom housing on enough service plots of land to meet the demand for self-build and custom house building in the authority's area. So you have to have regard to that duty, and you must, first of all, consider the duty, grant development permission for the carrying out self-build and custom housing on enough service plots of land to meet the demand for self-build and custom house building in the authority's area. So that's the duty. In terms of how you come to make up your mind in the planning judgment, as you're aware, there's two tests. You have regard to the development plan foremost, unless material consideration suggests otherwise. And what you're grappling with here is the material consideration bit, because the development plan you have MTRA 4, but we're now in the material considerations territory, which is taken into account the self-build, the duty, the need and the demand, and here in this case, unmet need.
Councillor Williams.
It's just a sort of further follow on from Councillor White, really, in regards to how short we are in regards to self-build properties in the Winchester district.
Thanks. So basically, as set out in the report, over the period from 2020 to 2023, there's a shortfall of 70 units. So that is the shortfall that we're looking at that needs to be met.
It's a fairly significant shortfall. Yeah.
Yeah, yeah.
Councillor Laming.
I'm struggling with this a great deal. We've got a local plan, which we've identified where we develop and where we don't. And how does that fit in with it? Because this site wasn't identified in the local plan and it's outside the boundary. And that's the bit I'm struggling with.
So you're right, Councillor, it's not been identified. Obviously, MTRA4 protects the countryside, and then we have settlement boundaries, and the plan dictates where those settlement boundaries are. That's why you're seeing in the report, obviously, the issue in terms of local plan policy is MTRA4. But if a scheme comes forwards saying that this is essentially South Build, it will be weighed in the balance against, obviously, arguably a conflict, which is MTRA4, which is what the officers identified for you. But coupled alongside that, there are other material considerations. And the material consideration for you is the South Build issue. So in go those two issues for the officer to make a planning judgment, to make a planning assessment. And in the final balance, what the officer is saying to you is that this material consideration, the supply and demand and unmet need for South Build and custom housing, tips the planning balance in favour of a permission, not only due to the South Build and custom house building point, but also because it's proximity, I think it was 80 metres, Liz, from Colden Common settlement boundary. So it's extremely close. So it's not just going into the balance, the issue of South Build unmet need, but also that it's extremely close to the Colden Common settlement boundary. And the other issues as well that the report identifies, that the scheme has been moved back, I think, from the woodland concerns, which originally attracted a reason for refusal, and also that there's now a package treatment plant to deal with the nutrient issue as well. So all of that goes into the balance on the material consideration side, and essentially the issue is for you, is there enough conflict here in terms of MTRA4, given its location and the other points, and how close it is to Colden Common? Or do you pay more heed and more regard, as the law says you must do, on the South Build point? So that's what you're grappling with, and I can see it's a difficult decision, but hopefully I've provided some clarity. All of these points about the South Build are on the material consideration side. You're right, it's not in the local plan, but it is a material consideration for you.
Thank you, that's very useful.
Councillor Clear.
I'm going to be a pain here because I can't get my head around this. A self-build, which we keep saying, is that where an individual may do some or all of the build themselves or employ a builder, architect? But in some cases, now I'm talking about a custom home built now, where would have a project manager, and I can't get my head around the difference between a custom home build and a self-build. Please excuse me, but I'm finding this a little bit difficult to understand.
I think, Councillor, what you're trying to do is, as a matter of fact, this individual is on the South Build register, South Build and custom house building register. So irrespective of the point you're making, this individual has met the criteria. They've been accepted onto the register. So you're trying to, if you like, look at the circumstances as to how that individual is on the register. The fact is this person is on the register, those tests have been met and they've been scrutinised, they paid the necessary fee, they meet the local connection, so therefore they're on the register. That's a fact.
I think I'm right in thinking that this emphasis on supporting self-builds is something that's come from central government, and it postdates our current local plan, so that this emphasis on forcing us to find plots for people to self-build is something that wasn't around when we were drafting our current local plan. Is that right?
Yeah, I think my understanding is that it sort of came back, well, it dates back to the housing white paper around 2017, which made it very clear at that stage that custom and self-build housing was something the government was very keen to support from about that period onwards, unless Dan's got anything else to.
No, I think, Chair, so the NPPF has obviously supplemented this concept of self-build and custom house building. Paragraph 63. So you have to have regard to the NPPF as well. Paragraph 63 deals with essentially delivering a sufficient supply of homes. So if I read that to you, within the context of establishing need, the size, type and tenure of housing needed for different groups in the community should be assessed and reflected in planning policies. These groups should include, but are not limited to, those who require affordable housing, families with children, older people, those who require retirement housing with care and care homes, students, people with disabilities, service families, travellers, people who rent their homes, and people wishing to commission or build their own homes. So not only is it in the statutory law, it's also the will of Parliament and obviously national planning policy.
Okay, so that might be changing soon, but for now, it's what we're stuck with. Councillor Lane, you have another question.
Sorry to be a pain, but the other bit that we need to understand is if you get yourself onto the register by paying the fee and doing the normal thing, does that mean then that you can go and buy land to build a house on?
I don't think anything stops anyone buying land upon which to build on, but doesn't mean they're going to get planning permission.
Yeah, they can classify it as a self-build, and then we're in this quandary again.
But they'll still have the other tests of the local plan to have to meet. And the reason why we're bringing this site to you today is because we just think it's one of those quite exceptional sites that actually it doesn't have any harm in any other respect. It's linked to Coldham Common and there's no landscape harm, and in all other matters it's acceptable. So yes, a self-builder can put themselves on the register, but they still have the regular problem of planning permission. If they find a good site, they might get planning permission by virtue of it outweighing the normal considerations of MTRA4, and we just think this is an exceptional site that perhaps does, which means that in the interim before our new local plan comes into play, which is allocating big sites with like percentages for self-builds rather than these isolated ones, this is a short-term interim measure to get our plan numbers sort of met up before we get our approved plan.
I think it's a combination of the facts here, Councillor. So the fact is it's quite close to the settlement boundary. So on its own facts, what you're deciding today, the application before you, all of those old planning adages that you have to decide the case and the application before you, this case is squarely on its facts. How close it is to the settlement boundary, how it's been negotiated down in relation to the woodland, the package treatment plant and so on. If, however, a builder wanted to just try and get planning permission for self-build and custom housing nowhere near a settlement boundary, squarely in the middle of the countryside, what you'll be presented there will be a different set of facts, and there will be different policies pulling in different directions, such as isolated homes in the countryside and the policy presumption against isolated homes in the countryside. But you don't have that here because it's not a case of an isolated home in the countryside. So this case is squarely on its facts. And I can see the fear in your mind about what's to prevent a self-builder who's on the register to go and buy any plot wherever. But that case will be decided on its own facts.
Okay, so this is a unique case, as is every application, in fact. So, and will not set any precedents.
Chair, I've got answer to Councillor Langford Smith's question about definition of a self-build. So the Act, Self-Build and Custom House Building Act 2015, Section 1. In this Act, self-build and custom house building means the building or completion by, no, both, the building or completion. Okay, it doesn't necessarily mean and building and completion, it could be one or the other. By individuals, association of individuals, or persons working with or for individuals, an architect, or associations of individuals of houses to be occupied as homes by those individuals.
Thank you very much. I think that's very clear. So members, have we finished with our questions to the officer? So we move to debate. Councillor Williams.
Thank you, Chair. It is a very difficult decision. I would be minded without the conditions to consider not supporting the officer's recommendation and not giving approval. However, I think the additional condition with the 3-year occupation time is enough to satisfy me that this isn't a self-build that's come forward just to build and immediately sell on. That period of time I think it is quite important here, as is the distance to the settlement boundary in Coldham Common. If this were further afield, further in the countryside, they're not serviced by utilities, I wouldn't be minded to support it, but I'm quite confident with the additional conditions that this will be an acceptable form of self-build in the countryside.
Councillor White.
Yeah, so it isn't an isolated house in the countryside. As we've said, it's linked to Coldham Common. And also I'd say it's actually, from what we've seen of the design and also the biodiversity and landscape improvements, I'd say overall it improves the character of what's actually there at the moment. So, and as well as taking regard of the substantial shortfall in self-build houses that we have a duty to look at.
Councillor Cunningham.
Thank you, Chair. I am worried and I am concerned that the pressure to meet the obligation to permit sufficient self and custom built dwellings in the district could end up driving a coach and horses through our local plan policies. This obligation should not contravene or undermine some of our most important policies as they apply to the countryside, MTRA 4 and DM 23 in particular. This application for an open market house does not meet any of the MTRA 4 criteria and is therefore contrary to the requirement of these policies. Whilst I appreciate the need to address the outstanding numbers in the self and custom built register, and that this is a material consideration, it should not serve to justify a clear undermining in our planning policy and permit development in the countryside which would otherwise not be permitted. Are we creating a precedent, I ask here? And will the outstanding 70 on the register also use this argument to build in the open countryside? I have no objection to these dwellings within settlement boundaries or locations in compliance with planning policy. I am of the view that the self and custom built argument does not carry sufficient weight to justify this development being built in open countryside, compromising such important planning policies. And I will not be supporting the officer's recommendation.
Thank you, Councillor Langford-Smith.
Thank you, Chair. As Councillor Cunningham just said, this application is contrary to the policy of development in the countryside, MTRA 4. The application hasn't shown a legitimate need for development in the countryside in terms of agricultural worker dwellings, etc. And whilst it is in close proximity to the settlement boundaries, it is actually outside. And we do have boundaries for a valid planning reason to permit development in the correct places. And whilst we must grant permission for service plots to meet demand, it's not to say that those service plots have to be in the countryside. I'm very conscious of the climate emergency, and I don't think that this application adds to helping the climate emergency. It is development in the countryside, which is contrary to policy, so I won't be supporting.
Councillor Clear.
I'm just going to say I found this very difficult, as you probably understand, but I totally agree with Councillor Cunningham and Councillor Langford-Smith, and for the reasons that you've set out. So I'm sorry, I cannot support this application.
Councillor Laming.
I think I concur with the previous comments on this. We've had problems in our ward with self-build, and whilst they claim that it was a self-build, they've moved people in it and rented the properties out, and I'm not convinced that this will not happen here. So therefore, I question whether it is a self-build. And it's also outside the boundary, and it raises too many questions. I think we need to be on a safe guard on that. I take quite seriously what our legal advisor said, because I think he's got a much better view on the legal situation than I have. But when I come down to the material facts, it raises a number of questions, and because of that, I cannot support this.
Councillor Small?
I agree with what Councillor Cunningham and Langford Smith, Councillor Clear said. However, with that added condition, I'm minded to support the officer's decision, as I'm satisfied that this doesn't set a precedent. At least I hope that that is definitely the case.
Can we just remind ourselves of the extra condition, or the beefed up condition 3 that we are considering here?
Bear with me, Chair. I'll just close down Windows now. So this is an inspectorate condition. It's not one that we've drafted in-house. It's on a different site in the country on an appeal. So as condition 3 currently is, but with the addition of the first occupation of the unit in the development hereby permitted shall be by a person or persons who had a primary input into the design and layout of the unit and who intends to live in the unit for at least 3 years. And secondly, the council shall be notified of the persons who intend to take up first occupation of the unit in the development hereby permitted at least 2 months prior to first occupation. That will protect the position that the occupier had an input into the design and layout. If it was banked and sold, a new purchaser will have to ask for a release of that condition because they did not have an input into the design and layout in line with the Act.
Ask one quick question then, Daniel. Can we stipulate that the person that created the self-build is the people that actually reside in the property for the first 3 to 5 years?
There was the councillor having a chat with you.
If they're self-built, they must be since they move in.
Yeah, so the planning officers have kind of reminded me that there will be a CIL exemption anyway for the person. So the person who builds this out, who then goes on to occupy, there's an exemption from the Community Infrastructure Levy, CIL, CIL. So you would expect, would you not, that the person who got the benefit of the planning permission would rightly apply for the CIL exemption, the Community Infrastructure Levy. So in a way, the parallel regime of CIL protects that point, because it would allow for that exemption to come forwards if they were building it and then wanted to occupy.
But
so it's there in a parallel regime,
yeah,
with those conditions that obviously
I take your point with that, but the experience that we had in our ward was that somebody claimed a self-build. They designed it for themselves according to when they applied for planning permission, but they didn't move in. They applied for the CIL exemption and they didn't move in for about 5 years. In the meantime, it was rented out. And I want to avoid that situation by saying that the people that build it must move into it, because then that's the only way we can classify that as a self-build.
So I think that's a really well put fear. So you've got an example where the development management regime did not obviously protect that position for you.
Okay.
But with this added condition, it's probably different to that particular case. Because this condition, it says the first occupation of the unit of development shall be by a person or persons. So if it turns out that that occupier didn't have input into the design and layout, then there's enforcement. It's a breach of condition notice here. There's no right of appeal against a breach of condition notice, unlike an enforcement notice. So the fact that this condition is stronger, the enforcement team can serve straight away a breach of condition notice with no right of appeal.
Thank you, appreciate that.
Okay, I think I'm going to have my contribution now. This is an extremely difficult decision because on the face of it, it is completely against NTRA 4, and I totally accept what Councillor Cunningham, Councillor Langford Smith and Councillor Clear and others have, with serious concerns, MTRA4 is fundamental to our local plan. It is fundamental to keeping our communities within boundaries. It is fundamental to protecting our countryside. And we have to have extremely serious reasons for going against MTRA4. And I accept that this is a very difficult decision. So this self-build is the list is as I understand it, you pay your money, you have your local connection, you put yourself on the list. It's an aspirational list. In my view, it's very like the aspirational lists that developers have of available development land around our settlements. It's aspirational, but whether we should accept that is a suitable reason to allow a new dwelling in the countryside is really very difficult. Now, I know that the government in the past has instructed us that we should make allowance for more sites available, suitable sites for people to self-build. And I think it's a great thing, aspirational thing, and and we are indeed making provision for more self-builds within our new local plan. But whether this particular site is sufficiently different, sufficiently that what is proposed is sufficiently sustainable, of beautiful sympathetic design, good for the environment, timber and flint, all good stuff, but whether it seriously will not cause harm in the countryside, I'm finding it very difficult to see that myself. I do think, especially since, just at the last planning committee, we were fighting, over the ditches to stop a new dwelling literally across the road from the development area of a village, to then turn around and say, no, actually, this is fine. I mean, it's a huge site. It's a very large building. That's not my reason for considering that it's inappropriate. But it's not. I am not convinced that it is sufficiently sufficient that no harm is going to be caused. I am not convinced. I do think that this will significantly impact on MTRA4. I think all those on the self-build register will be hunting around for sites near our communities and stretching that boundary and making that red line fuzzy, and I don't think that we should. So I think that I won't be supporting the officer recommendation. But let's see how the vote goes. So are we there now, members? Is that all our debate? Yes, I think we've all contributed, haven't we? So this application is recommended for approval. Can I see those in favour of this application, please?
That's 3, Chair.
And those against?
6, Chair.
So that recommendation falls. So we now have to agree our planning reasons for refusing this application.
Chair, it's very clear what I'm hearing from members of the committee today, that you're simply not finding that there's substantive enough weight to outweigh the very heavy weight that you place on the policy of MTRA4. So our reason for refusal should very simply reflect something like that. Just
DM23.
So is that in respect of the visual harm because it's located in the countryside and the size of the dwelling?
Yeah. Yeah.
She did. No.
Okay. I think that we can between us sort out based on those policies and our.
So to clarify, then it would be a reason in respect to the visual harm and the character in its location in respect of DM23, and then also having regard to the development being self-build, that it's not considered that that's a justification. We'll find the right word for that for additional residential units, which is is strongly protected by policy MTI4. So we'll, if you delegate that back to us, we can agree that specific wording if members want to vote on those two
Thank you.
reasons.
Thank you. So members, on those reasons then for refusal, can I see all those in favour of refusing this application? I believe that's all members.
Unanimous.
Thank you very much. Thank you, members. We'll have a short break whilst we change our presenting officer. Thank you. Members, if we could sit down again, please. And sorry, what was supposed to be a very brief pause turned into quite a long break, but I apologise for that. So we're now on item number 7 of our agendas, Crowhurst Kennels, Sutton Wood Lane, Byton. And our presenting officer is Megan Osborne. Over to you, Megan.
Thank you, Chair. I'd like to draw your attention first to the update sheet. There's an amendment to page 56 of the report to the reasons for the recommendation. So it should read, the development is recommended for refusal as it represents a new dwelling in the country, residential dwelling in the countryside, without justification contrary to local and national planning policy. Start my presentation. The application site is located on the eastern side of Sutton Wood Lane, just outside the boundary district, which is the black line here. There is an existing dwelling on the site and an outbuilding to the east of this, sorry, a building to the east of this. To the north of the dwellings, there are 3 buildings that were used as kennels. These are now redundant. To the north and west of the site, there is an ancient woodland, which is marked out by the hashed land here. And running through the woodland is a public footpath. You can just see it here. Okay, this is an aerial photo of the site. So you can see the existing dwelling on the site there, the woodland, and then the kennel buildings, which are here. The proposal is to demolish the existing kennel buildings and replace with a single dwelling and detached garage. You can see the kennel buildings here, 3 of them, and propose to demolish them and replace with a dwelling and then a garage here. This is a resubmission of a previously refused application. This was refused previously for 3 reasons. 1, because it resulted in a dwelling in the countryside, for which there was insufficient information. 2, the proposal would result in a development in the buffer zone of the neighbouring ancient woodland. And 3, the lack of nutrient details. The applicant has not addressed the concerns in relation to the reason for the dwelling in the countryside, but provided information to address reasons 2 and 3 of the refused application. Right, this is the existing plan. I think the next one, yeah. In order to address reason for refusal 2, a revised plan has been submitted relating to the buffer of the ancient woodland. This restricts the residential curtilage and the pond to the area outside the 15-metre buffer of the woodland. And this is now considered to be acceptable, and therefore this reason for refusal has been withdrawn from the application. In relation to condition 3 relating to nitrates, a revised nitrate or nutrient plan has been submitted with a solution in relation to the mitigation of the nutrients that would have been produced for this one dwelling. Natural England have agreed to this approach, and therefore this reason for refusal has been withdrawn also. So these are the proposed floor plans of the dwelling. This is it's a single-storey dwelling, and this is the roof plan. And the elevation, this is the north elevation. The total height is 4.8 metres. Elevations. And this is a section of the site running through it. So on the right hand side of the screen here, you can see the existing dwelling house and the proposed dwelling here. You see the land slopes down, and then the ancient woodland is to the left. You see the tree there. And this is a plan just showing the existing outline of the kennels. You can see that in red. So the 3 kennel buildings, and then the proposed dwelling here. To take you through some, oh sorry, this is a visual of the proposed dwelling and some photos. So this is the existing kennels on the site. And then to the left of the screen is the existing kennels, and then you can see the existing house straight in front of you. And again, another photo of the kennels. And then this is the existing dwelling that's already on the site. And this is the ancient woodland that wraps around the site. And again, the kennels with the ancient woodland beyond. Two of the reasons for refusal have been addressed by this application. However, the proposal is still contrary to policy MTRA4 in the Local Plan Part 2, in that it is a residential development on land defined as countryside in the local plan, and therefore is recommended for refusal for this reason. Thank you, Chair.
Thank you, Megan. We now turn to public speaking, and we have the supporters, Richard and Pat Bacon. If you'd like to come forward, please. Thank you for coming this morning. You have 3 minutes, and the microphone is turned on by just pressing the button on the base of the unit. Have you decided, well, presumably you know how you're going to share the time. That's fine. Thank you very much.
Good morning, councillors. We are here today to persuade you to approve our application to replace our derelict kennels with a net zero passive house. The kennels are derelict because they no longer meet the regulations for boarding dogs, and upgrading and replacing the kennels would be a cost that the business would not carry. We think a new dwelling would be the most effective use of the land and not be out of keeping. From your report, you'll see that the previous objections regarding the Solent and ecological and woodland stuff has been removed. The remaining objection relates to the location in the countryside. And whilst many of us, in many circumstances, policies are essential for good planning, the report admits to note that this is currently a brownfield site and a blot on the landscape. And here I'm thinking of the government's drive to encourage new homes and brownfield sites. I'd like to make the point that we're not taking away or diminishing the countryside in any way, which is what's behind your policies. In fact, we are reforming a derelict brownfield site in such a way that we think is a benefit to the countryside. And the benefit is best demonstrated, we believe, by the calculated biodiversity net gains that we have shown. These are, for us, it's 68%. And with a gain of 243% for the hedgerows. And these figures are not given in your report. Our proposal, which is for a self-built dwelling, is to allow us to downsize and to grow old gracefully, and in no way diminishes or detracts from the local character. We say it enhances it by removing ugly buildings that currently exist and returns much of the concrete and buildings to green space. That's how we've been able to achieve the buffer zone that's required. This is not just what we think. We are only here today because of the local support we have received from many of our neighbours who recognise the benefits of the scheme. We've had no objections. The application focuses on a sustainable dwelling with low carbon demands. It replaces a derelict brownfield site no longer fit for purpose. It meets many of the national and planning policies and recognises the climate emergency. Food for thought.
Thank you for listening, and it is a self-build project. We have built it in design for our older years, particularly myself who has arthritis and already has had one hip replacement. Thank you very much indeed.
Thank you very much. Thank you for coming along this morning and your contribution. If you could just wait, members may have questions of clarification. I have a question. Given the previous refusal and MTRA4, which is very clear that there shouldn't be new dwellings in the countryside without proper justification, has it not occurred to you just to demolish the kennels if they're no longer used and return the land to grass or woodland? Or
We think the site still has a value, and of course we've made an investment in it. Which is a brownfield site. it would be difficult, I think, to totally remove the brownfield site. But we do think that a dwelling is the best use of that site. It improve it visually, I think. Do you have anything to?
Yeah, sorry, I'd like to add that the kennels on, if we could convert them into a barn, like, say a barn, we would do that, but they are totally unconvertible. They are not tall enough in one instance. So that's the reason. Otherwise, we'd have 3 small barns, etc., developed into a suitable dwelling. It is brownfield. We can't use them for anything else.
If I might add, another option possibly for us would be to demolish the kennels and build some kind of holiday accommodation, which I believe would be permitted or would be looked on more favourably. But that's not what we do. We want a place. We want to stay in the village. We can't do that because there's nothing in the village. We want to stay in the village. We feel part and we feel at home in the village. We want to stay there, and this is the only way we think we can do that.
I will add that we're very eco-conscious and we're very keen to maintain the woodland and the surrounding areas. We are quite green, as many of the villages would tell you that.
Lovely, thank you very much. Thank you for that reply. Yeah, Councillor Cunningham.
Thank you, Chair. Mr. Bacon, you mentioned self-build a minute ago. Are you on the register?
We are on the register. More out of let's see what happens, rather than we haven't brought this to you as the last applicant has. We're not trying to say that self-build is a sufficient material consideration. We think there are several other material considerations which are appropriate here. And it's those material considerations to do with the derelict land, the brownfield site, improving the visibility, improving the look of the lane, if you like. That those are the reasons why we have brought this to you in the shape it is. I must admit it was somewhat of a surprise to read the previous details of the previous agenda item. Honestly, we haven't thought about doing that, basically. We bring it to you to balance, just as your legal advisor says, it's a balance between your policies and material considerations. Your policies I understand and respect, but in this case I think there are material considerations that I've mentioned that should be given more weight.
Thank you very much. Thank you.
Thank you.
What I would say is if we returned it to kennels, we use the woods a lot for walking the dogs, and that would be what would happen, and it would destroy the woods. One thing we noticed was how badly the dogs destroyed the ancient woodland, but it was kennels, it was our business. This is what we had to survive.
Thank you. Thank you very much. Thank you for answering our questions. Do we have any further questions for clarification? No? Thank you very much. If you could switch off the microphones as you leave. Thank you. Megan, do you have anything to add following the contributions from the public? No? Members, time for questions on the whole report to our officer, please. Do we have any questions for Megan? No? So we move to debate. Is there any debate on this item? Councillor Lamy.
Thank you, Chair. This is a very difficult decision again. However, I think this is a good report. It outlines the planning position, and I should be supporting the officer.
Councillor White.
So obviously it's a brownfield site already that's got something there that's fairly ugly perhaps, but I can't see any real material considerations that would justify a house in that area as it stands.
Councillor Langford Smith.
Thank you, Chair.
The debate on the last application actually helped clarify my thoughts on this one, and it just confirmed that policy MTRA4 is very important to myself personally and to the committee. So I will be supporting the officer's recommendation.
Councillor Clear?
MTRA4. I support it, so I support the officer's recommendation for refusal.
Councillor Cunningham?
I echo everybody else's comments. Thank you.
You can reflect that in your vote, Councillor Cunningham. So if there's no more contributions to debate, Councillor Ashwell.
Yeah, just the same. I support the officer's recommendation.
Okay, lovely. Can I see all those in favour of supporting the officer's recommendation to refuse this application?
That's 9 unanimous, Chair, for
Thank you very
refusal.
much indeed. So I'm afraid that application is refused as per the recommendation. So we will now take a break, if I didn't get one last time, of 15 minutes. We will resume at 11 o'clock. Thank you very much. Okay, sorry about that slight delay, technical issues at this end. So, welcome back to the Planning Committee, and we are now on agenda item number 8, which is at Westview 30 Rosebery Road, Alresford, and our presenting officer is Charlotte Smith. Welcome, Charlotte, and if you'd like to give us your presentation, please.
Thank you, Chair. This presentation is with regards to alterations and additions to an existing chalet bungalow in Alresford. On this slide, you can see the location of the property, surrounding which is an eclectic mix of properties in terms of height and design. The property itself is within the settlement boundary of New Alresford, between Grange Road, which runs to the north, and the B3046, which runs to the south, and it's to the southern end of Rosebery Road. The second slide showcases the aerial view, and the property itself is indicated with the yellow star here in the middle. And you can see the sort of different roof designs that surround the property. This shows the proposed site layout. You can see the proposed decking, which is now subject to condition 8, and the surrounding trees, hedgerows, shrubbery that are around that border the property. Slide 5 showcases the existing floor plans, including the roof, which evidences the lack of usable space. Slide 6 shows the proposed ground floor layout along with the proposed decking, which runs down here. Slide 7 shows the proposed first floor. On the bottom here, you can see the window subject to condition 4, which serves the bathroom. The only access in terms of the sedum roof over here is in terms of maintenance as and when required. The terrace itself is closed off, which restricts views to the neighbouring properties. Slide 8 shows the proposed new roof plan, which is designed to maximise solar potential. Slide 9 shows the existing elevations in relation to the proposed elevations. As you can see, it's quite a sizable increase. Slide 10 showcases the view of the property from Rosebery Road. And you can see it there marked by the yellow star again. And you can see the property in the background, which is quite sizable in comparison. This showcases the view from the rear garden. You can see the slope of the garden a bit better from here. The topography of the land slopes downwards. That's the existing site model. Gives a bit more of an interactive view of the property. And then finally, there are some additional area photographs, all of the immediate vicinity, which showcase the eclectic mix that surrounds it of both 2-storey, single-storey and 1.5-storey properties. Thank you, Chair.
Thank you very much. And we have an update on our update sheet, an amendment to condition 4 and an addition of an extra condition, condition 8, about the decking area. So just drawing those to your attention, members. So now we move to the public speaking, and we have first an objector speaking on behalf of John Sutton. We have Lucy Sutton. So Lucy, if you'd like to come forward, you will have 3 minutes, and the microphone is switched on by pressing the button, and a clock will appear on the screen to tell you how much time you have left when you're ready. Thank you.
Good morning, Madam Chair and members of the committee. My name is Lucy Sutton and I'm here on behalf of my dad, who unfortunately cannot be here today, and I'll be reading his statement. My name is John Sutton and I live with my family at 32 Rosebery Road, which is the property bordering the application site on its southern side. As a family, we have lived at number 32 since 2016 and my parents before me since 1995 when the house was built. We currently enjoy the peace and quiet of our property, which is completely private and not currently interfered with by any of our neighbours, of which there are 3. The proposed development at 30 Rosebery Road will alter all of this, as south-facing windows will overlook our front, side and rear gardens and lead to loss of privacy, and the raised platform will inevitably generate an unacceptable level of noise and disturbance to our rear garden, both of which are of considerable concern to us. The scheme proposes 5 windows that overlook our property. 4 are within 4 metres of our boundary and the other is 7 metres away. I have spoken to the case officer on this and was told that by condition the windows will be obscured and fitted with opening restrictors. Having read her report, I'm dismayed to see that the obscuration is by way of an applied film and there is no mention at all of opening restrictors. I'm aware that development with potential for overlooking and loss of privacy is generally not supported by planning authorities, and I would respectfully ask that the planning committee strengthen the glazing condition by requiring the glass itself to be obscured and the glazing to be fixed. This would remove any potential for overlooking and would be acceptable to us. Of equal concern to me is the raised platform which extends across the rear of number 30 and wraps around the side facing our property, extending to within 1 metre from our boundary fence. This is a significant aspect of the development which I feel has been completely overlooked by the case officer and has the potential to cause significant interference and harm to the quiet and peaceful enjoyment of our rear garden. It is proposed that the ground floor and platform will be at the same level, and whilst the application proposal indicates a regular ground level condition to the rear of number 30, the submitted topographical data indicates that this is not the case at all. In reality, the ground floor of number 30 is 800 millimetres above ground level at the southwest corner, and by extension of this data, I have determined that the proposed deck will sit 1.2 metres above the rear terrace of number 32 at a height equal to the boundary fence. My own section drawing uploaded to the council's website indicates the correct effect this proposal will have on our property. The case officer has told me that in her opinion the terrace would be permitted development and therefore considers it outside the scope of planning control. Having checked this with a planning consultant at Southern Planning Practice, I'm told that raised platforms higher than 0.3 metres are not permitted development and are requiring of a planning consent. I would kindly ask that the planning committee refers this matter back to the planning officer for proper scrutiny, as the effects of this aspect on the quiet enjoyment of our property are likely to be considerable. Thank you.
Thank you very much. Do you think you could answer any questions of clarification from members?
Potentially,
on
yeah.
behalf of your dad?
I wish he was here, but he's just recovering from a serious
Oh,
operation.
bless him.
so-
Well, please pass on our very best wishes
Thank
to
you.
him, won't you? Thank you. Okay, members, do we have any questions of clarification? Councillor Williams.
Thank you very much, Chair. It was in regards to, you mentioned that if there were sort of conditions on the windows in the breadth of which they can open and the obscurity, it would be sort of more an acceptable development for you. If, you know, as conditions in the obscurity sort of size of things, in condition 4, do you think that would sort of be acceptable from that side of things?
If that's what my dad has said, then yes, but he's not here to read it, so.
Sorry, it is a bit unfair asking you on his behalf.
Has he been sent this document, do you know? Or this has just come out today?
It's on the website.
Okay, all right.
And then the further one was there was an extra condition added in regards to the decking. So there would have to be a separate design sort of submitted in regards to the decking to ensure that that's not overlooking as well. Do you think that sort of would sort of satisfy those concerns as well? Sorry again.
He told me you wouldn't ask any questions, so.
Shall we read it out to you? It says, the decking area shall not be constructed until details have been submitted to and approved in writing by the local planning authority, showing screening and boundary treatments to prevent overlooking of the neighbour to the south from its raised height. Development shall be carried out in accordance with the approved details and thereby retained for the lifetime of the permission. So that means basically that we need to see their plans for how they're going to make sure that there is no overlooking from that
Yes.
terrace.
I think that's what he said, didn't he, in the statement?
Yeah,
So-
so that's condition 8. So
Yeah.
hopefully that covers that
Mhm.
concern. Okay, well, we'll look again at the windows when we get to questions to the officer. Thank you very much, Lee, for coming along.
Thank you.
If you could just, that's it, perfect, thank you. Thank you, and our next speaker is Councillor Anne Bean from the Parish Council. Hello, Anne. Welcome. I think you know the routine, do you? Yes, and you will have 3 minutes as well from when you start speaking. Thank you.
Good morning. Thank you for bringing this to your planning committee. It's the first time in a long time you also council have asked for something to be represented here. And the main concerns, even though with their comments, we haven't objected to, but we do have concerns going forwards. As you'll no doubt aware, New Alresford is a very highly sought after residential area. And we are in the process of formulating a neighbourhood plan. We've had a housing needs assessment completed by ACOM, which has shown the lack of affordable housing in Alresford and the lack of smaller properties. Our main concern, or one of our main concerns, that this is an example of a smaller affordable property in Alresford that would be suitable for first-time families, taking it and not just extending it, but completely redeveloping the property and putting it into a different category of housing. The massing on this isn't the first. Then again, the reason that we brought this time, there's been a pattern that seems to be happening over the last year of smaller properties being completely demolished and started again, and that in our opinion, it just starts to change the housing stock in the town. On the planning side of things, we are concerned of the potential that the elevation of the extension may impose on the street scene. It's going up. I mean, the massing, I think, is doubling on it. We're also, one of our other concerns is that the materials used, in particular zinc, may not be in alignment with local characteristics, which is outlined in the design statement, and I think was also brought up by the urban design, that the zinc, I'm not aware of zinc being used in any properties in Alresford. So that's really, we don't have a major objection, but we just are concerned of the way that things tend to be going. Thank you.
Thank you very much. Members, do we have any questions of clarification for the Parish Council representative? No? I think you were very clear. Thank you very much indeed. Thank you. Okay. Finally, we have a supporter, 2 supporters, Jonathan Moore and James Fair. If you'd like to come forward, gentlemen, good morning. And you will have 3 minutes between you, so I assume you've worked out who's going to do the talking, and presumably the other one is to help answer questions. Anyway, I'll leave it to you. You have 3 minutes from when you start. Thank you.
Right. Good morning, Chair and committee members. Westview is an example of how our country's existing housing stock can be retained, adapted and reused to provide a family home that will suit modern day and future standards. The simple choice for the owner could have been to knock down the existing house and replace it with a new, poorly built stick building that so many of us see and despise on everyday travels. Instead, the owner has decided to retain the vast majority of the structure and its embodied carbon footprint and add a new thermally efficient, highly sustainable series of additions to create a new family home that will provide for now and well into their future. These include a high thermally efficient SIP structure to the upper floor and roof elements, new internal insulation to the ground floor walls and floor elements, a new air source heat pump supported with flush mounted PVs, which will provide domestic hot water and heating, and new high performance doors and windows, all providing for a building that targets a net zero carbon footprint in its everyday use. The new first floor addition, the new first floor addition has been carefully considered in relation to its immediate neighbours and the wider context of Rosebery Road. It respects the neighbouring ridge heights in terms of overall heights and their setbacks at both the front and rear of the properties. These diagrams are all demonstrated in the design and access statement which was submitted. It reflects the local style in its use of small gables that face the street setting it within its context of traditional vernacular architecture. It is of comparable scale to many of the houses along Rosebery Road. This has been demonstrated in the consultation process with both the planners, Winchester and Eastleigh Design Review Panel and the Town Council. The language is of today. It represents the manner in which the additions will be built and provides a wholly appropriate language for its setting. What is new is reflected in a single, well-detailed and considered material of zinc, whilst the retained remains as it is in brick. The City of Winchester and its members are advocates for well-designed, well-considered contemporary architecture that can only add to the diversity of its architectural heritage. Many modern buildings sit alongside their historical neighbours and add to the character and diversity of their locations. I know this as I've lived and worked in Winchester for much of my professional life and have added successfully to a number of its architectural areas. We very much hope that committee members and the chair look favourably on this application and see it for its merits, both in terms of adaptive reuse of an existing dwelling and the proposed enhancements to bring the home up to and beyond modern day standards. Thank you.
Thank you very much. Members, we now turn to questions of clarification to our speakers. Can I just ask, I know it would be permitted development, but there have been concerns raised about the noise emanating from the heat pump. Can you just very quickly reassure neighbours that that is going to be in some way encased in
Yeah,
some sort of
so air source heat pumps are pretty much the modern way of heating new buildings these days. They're very efficient. They are actually quiet. Yes, they do run continuously, but actually if you want to acoustically protect them, you can put them into acoustic enclosures.
And is that planned in this case?
Well, in this case, the air source heat pump is on the northern side between an existing brick building and a fence line.
Right.
So actually we deem that because the noise is coming out to that level, it shouldn't be an annoyance to neighbours. But if it is,
But if it
then
was a problem, then something.
it can, an acoustic closure can easily go around it. Yes, yeah.
And you note the addition of condition 8. Is that going to be acceptable? And
Yeah, I think it's important to stress that there's already a deck there, and
Right.
what we're doing is we're not really changing the use of that deck. So at the moment, the residents can go out, they can sit on that deck.
And is
They
it at the height that it will be with the?
So at the moment, it's 150 mil below finished floor level. For modern day standards, you want level access, so we're raising it by 150 mil. That's all.
Okay.
It's also worth noting that the boundary conditions on that side, there is extensive screening, but it's maintained by number 32. And at the end of the day, if they want added privacy, then they should let the hedge grow. That's the reality of it. From our point of view, if we wanted to put a 1.8 metre high fence on our boundary side, then we'd be happy to do that.
Okay, well, that's to be decided, I think. Okay. Members, questions? Councillor Laming.
Thank you, Chair. We hear from the parish council about the use of zinc.
Yeah.
Cladding on it. That does have an effect on the rest of the street.
Yes.
So I just wondered why you chose that rather than something more conventional to fit in better.
Okay, so we took the design to design and review panel at pre-app stage. We gave them 6 different variations to show how this design was developed, and through consultation with them, they came back and said this was the preferred option which we developed up, and it was their view and our view that actually when you're adding a new addition, we wanted to keep the languages quite simple. What's existing is brick and what's new is in metal. We gave them several options to show different materials, and they actually came back and said it looked too fussy. So what we did, we're going by the recommendations of design review. They are, my peers. I sit on it as well, so I know where they're coming from. And at the end of the day, it's contemporary architecture. We know Winchester and Eastleigh are advocates for it. And yes, it may be slightly different, but actually the contextual form is no different to anything else within that street. And it adds diversity, it adds character, at the end of the day. So we would be prepared to change it, but our stronger view is that actually it's part of the design at the moment.
Yeah, I mean, I speak from experience that we've got several in my ward, 1 or 2 which aren't reasonably acceptable, but there's at least one which is horrendous and creates it was described as being better fitted to an airfield than
a
residential road, and that's the bit that concerns me.
Yeah, I understand that concern. I think zinc, when it's detailed right and it's designed correctly, zinc buildings can look very elegant. They're all over the place. You know, as long as it's detailed right, and I think that's what design review was getting across to us, was that as long as this is executed well, and it will be, then actually zinc isn't it's not an alien material. From the applicant's point of view, zinc is also highly sustainable. So, you know, it's got a long life, it can be recycled. It's probably a better use material than, say, for instance, timber in these days, or clay tile, because they have different properties to them. So at the end of the day, you see a lot of zinc clad buildings because of its environmental credentials at the end of the day.
Yeah, and the other question was about the ground source heat pump. Are you quite happy to have it conditioned that it's got soundproofing around it, because these run at night to be most efficient for that, and that does cause problems within the neighbourhood because
yes, as long as the air source heat pump's got 300 mil of free air around it, then we can put an enclosure around it at the end of the day. Yeah.
Thank you.
Okay, I think we've been reassured on the heat pump. Councillor Cunningham.
Thank you, Chair. Concern has been raised by the neighbours in number 32 with regard to overlooking. And I think that's specifically with regard to windows on the south side of the building to their north side of their building.
That's correct, yes.
Can you tell me what windows are in their north side of their building?
On the north side of their building?
Yes.
There's when you look from the upper level of the applicant's site number 30, you can see a dormer window in their hipped roof. So when they refer to overlooking, if I was living there, what they're saying is that if you stand at a bathroom window, because you're at first floor level, you can look into their garden. But all of those windows on the south side will be opaque. When we're talking about opaque, we're not talking about the film that's put on. We're talking about a type of Pilkington glass which has got the opaqueness set into it. So it's part of the frame system. So therefore, although there are windows on that south side, they're all secondary. They will be opaque, and therefore there isn't going to be any overlooking issue of number 32.
So you're saying all the windows. So there's 2 bedroom windows there. Are you going to opaque glass those?
Yeah. So those 2 bedroom windows, the one on the south side, the one on the west side is set much further back, and the one on the east side outlooks onto the front driveway, of which there are no windows there. So the overlooking from both of those windows is vastly more restricted than the ones which are up against. Yeah, so if you look on that plan there, the bedroom on the, if you look on the, can you go back to the first floor plan, please? Yeah, so first floor plan. So you'll see the master bedroom. There is a small slot window there, 440 mil wide, and it overlooks the green ceiling roof. That is well beyond 8 metres away from the neighbour's boundary, so we don't consider that to have an overlooking issue. It's also low set down, so it's not at high height. The bedroom immediately next to that has got 2 aspects. It's got one aspect to the west, which will be clear glass, and it's got one aspect to the south, which can be opaque because it's on that southern boundary. You then get the bathroom, which will be opaque by its nature anyway, because nobody wants to be looking into a bathroom. The window next door to that can also be opaque, and then you've got the window which looks onto from the front bedroom, which looks directly onto the driveway. There are no windows for it to look into. It's a front driveway at the end of the day, so it's not an amenity space. But if it was necessary to have that as opaque, then of course we're going to accept that as being opaque rather than get a refusal. Well, so there's ways of negotiating on that. I'm
just querying it because the update states that one bathroom on the south elevation will be glazed and obscure glass, whereas it says that all of them in the document is in our pack.
Says when you look at, if you can go back to the elevation again, please, you'll see that the windows which are dark, those are the windows which we're referring to as being opaque. Okay, so if you look at the bottom right hand elevation there, you'll see that you've got the bay window for the bathroom, which is dark. You've got the immediate window next to it and the window to the left. They all overlook the garage, and those ones are the ones which have potential to overlook number 32. But you've got to remember as well that there is a substantial planting screen there already. And so whilst the neighbour talks about this change in level, which there is, our reality is that when you actually stand there, you see very little of their garden space. But we're not objectionable to having them opaque, which is why we're showing the drawings as being opaque.
Thank you. So we can raise that with the officer and perhaps add that to the conditions, councillor Cunningham.
Thank you.
Okay, thank you very much. If there's no more questions of, oh, councillor Ashwell,
Thank you, Chair. I'm just trying to check on the plans. Are there going to be any solar panels?
Yes, so what we've done is, because of the way the roof's orientated, to keep those gables smaller in relation to the surrounding buildings, that gives us the ability to have 2 south-facing roofs. Those solar panels are integral. So rather than being bolt-ons, which you traditionally get with, say, a clay roof tile, with zinc, you're able to set those tiles completely flush with the zinc work.
lovely. Thank you very much indeed, gentlemen. You may return to your seats now. Thank you.
Thank you.
Charlotte, did you want to add anything before we get to members' questions?
No, thank you, Chair.
Okay, members. So we'll take questions on the whole report. I think we have discussed the issue of the obscuration of windows overlooking the neighbour. So perhaps we can add those other 2 windows to condition 4. Is that possible?
Yeah, yes, Chair, I believe so.
We can put more specifically the first floor windows with an S serving the bathroom, dressing room and bedroom on the south elevation, so it matches to the grey ones there if members feel that's necessary.
I think that would be taking a belt and braces approach, but since the architect has said that that's what they're planning to do anyway, we might as well condition it. Thank you. Just to reassure the neighbour, really. Councillor Langford-Smith.
Thank you, Chair. Can I just confirm that the windows that are in the loft, we're assuming that they will open but not be able to overlook the other properties?
Yes, that's correct.
Thank you.
Any further questions on the whole report, members? Claire, the TV's threatening to switch off. Sorry. No more questions? So we move to, sorry, I'm sorry, you've had your opportunity. I think we've covered the queries that you had about the decking and the windows. Yes, we have. We've covered the decking. We've covered that, and it's covered by condition as well. Yes, it's only apparently there's an existing decking, and it's only going up by a small amount. So, okay. So members, debate. Councillor Williams.
Thank you, Chair. I think it's a very well designed property, taking in regards to the climate crisis. So very much welcome that. I did have initial concerns about the overlooking aspect in regards to the neighbours. So I'm very welcome to see the amended condition so that it won't be overlooking the neighbours' properties. The glass will be obscured. As well as the condition in regards to the decking, in regards to there'll be a further submission of details in regards to the decking and screening. So I'm happy to support the officer's recommendation as the site fits in with other neighbourhood properties as well.
I think I'll just say a few words if I may. I did actually go and visit the site, just do a drive-by. 2 days ago, and it is very much an eclectic mix, as the officer said, of housing around there. And both houses on either side of this, I think probably a 1930s bungalow, 20s or 30s. I mean, it's quite an old bungalow. Have been either rebuilt or completely changed from the original bungalows, which presumably were there. I take on board the concerns of the parish council, and I agree that there's a huge amount of building going on in Alresford at the moment. You just need to drive around to see it's going on all over the place, and you are losing a lot of small homes. And I do hope that you will be able to address that in your neighbourhood plan. I think it's probably too late in this case, and that horse has probably bolted. It looks anachronistic now, that bungalow in amongst these very large family homes. But I do want to echo Councillor Williams and say it's a very well designed, environmentally friendly. You know, it ticks all the boxes. It's exactly the sort of thing. And and you're not demolishing the original bungalow. You're embedding that carbon in the new home, which is brilliant and very much what we want to see going forward. There's so much embedded carbon in all these old homes that they're not fit for purpose anymore, and they're difficult to heat and all the rest of it. So well done in looking at that and incorporating that into the new home. I was concerned about overlooking, and it is a big house, and it's going to basically fill the plot. But I think that with the obscuration that you have offered, and we will condition on the windows that potentially could overlook the neighbour, I don't think it's going to be an issue. And with the addition of condition 8, I think that the queries about the decking area will be addressed to everybody's satisfaction, and I'm sure that they will want to be good neighbours anyway, and cooperate with the neighbours on that. So in bearing all of that in mind, I'm happy to accept this as recommended by the officers. Are there any more contributions to debate, members? No, so we go to the vote. So this recommendation is to permit this application. Can I see all those in favour?
9 unanimous, Chair.
Thank you. So that application is approved with those 2 amended and additional conditions. Thank you. We now need to move on to our final item on the agenda, and that requires just a short pause. It's not an allowance to go make coffee, members, whilst we change over presenting officers. Thank you. Okay, members, I believe we're ready for our final item on this morning's agenda, which is number 9, and it's a TPO application to confirm a TPO at St Bartholomew's Church, King Alfred Place in Winchester. And our presenting officer is John Bartlett. Good morning, John.
Morning, Chair. Thank you. So this is for the confirmation TPO 23484 for 2 lime trees. The lime trees are situated in the St Bartholomew's churchyard, just to the northwest, adjacent to Hyde Church Path. These are the aerial photos that show the 2 trees, and what it shows there is a significant gap between these 2 remaining trees and the other tree that's on the edge of the row of trees there. So they're one of the few remaining trees in that particular section of the churchyard. And this is a view of them from the churchyard, and they have a good level of visual amenity and also contribute to the character of the conservation area, this location. And then this is the view from Hyde Path as well. So these are mature lime trees that have been previously pollarded, and so they've had that management undertaken for a number of years, and this is a frequent management practice that's used on many lime trees across Winchester. So the reasons given for removing these lime trees is to do with the decay that's been found in the upper part of the lime trees. But in terms of giving the evidence as to why they need to be felled, we haven't seen the extent of the decay that's been alleged. So we don't believe there's enough evidence to for them to be totally removed. But we have indicated an alternative form of management where these trees would be taken down to lower pollards, as shown with these two trees that are also in Hyde, in St Bartholomew's Church. And these are now at 3 to 4 metres, so they're lower pollards, but over time they'll be able to form rounded crowns, as shown with these trees here. But the proposal is still to fell these two trees as a result of the previous Section 211 notice that was issued to us. So our recommendation is to confirm 2348. Thank you.
Thank you, John. We now move to the public speaking, and we have Mark Merritt, who is the agent. And I believe you have a presentation for us as well, Mark. Okay, I'm sure our officers will sort that out. And when you're ready, you have 3 minutes for your presentation.
Thank you. I'm Mark Merritt. I run my own company in Winchester, Merritt Tree Specialist. I'm also a professional tree inspector under the Lantra Awards. The reason for objection to the TPO is that they don't actually fully meet the criteria for TPO consideration. So to be considered for a TPO, they must be of high amenity value and of reasonable condition. As you can see from the picture, that doesn't really constitute high amenity value. And with good condition in mind, the top of that tree is actually on the floor. We were asked to provide more information during the notification period of this notification, and that section of tree actually fell off during the 6-week period that we were doing the paperwork. Also, I think on that first picture, it's not very clear, but there's a fungal bracket just in the top fork, in that main fork up on the right hand side, which we believe to be Phellinus, which is a decay fungus that attacks the internal timber of the tree. So that renders it weak and liable to failure. So with regard to that, I mean, the visual impact of that tree, as you look at it, is pretty limited. And the amenity value is very low. It offers no screening to the other properties from those properties because they look directly out onto the church, and it is a limited contribution to the character of the area due to them being heavily topped in the past. Historical importance, they don't actually have any historical importance in the churchyard, and they can't be considered a rarity. They're lime trees, they're classed as common lime trees, they're not rare at all. So due to the proximity to the footpath and the ongoing major concern for health and safety, the longer they're retained, the more of a danger they become to the public. So in summary, would removal have a significant negative impact on the local environment and the enjoyment by the public? I don't think so. None of the local residents are happy with the trees or the way that they look. Would removal significantly impact the amenity on the area? Again, no, they're in terrible condition. I think you can see that from the pictures. So I think replanting would be the best option. And is the tree dead, dying or dangerous? Well, clearly, given the fungal bracket on there and that extent of that decay in that fork, which is now peeled off and is now on the floor in the churchyard, I think we can all agree that that is dangerous. So thank you.
Members, do we have questions of clarification for Mr. Merritt? Can I just ask, do you know what the church would like to replace these with?
I don't, to be honest with you. I don't think anyone's actually come up with a clear plan of what they want to put in, because we were told we couldn't take them out. They're now sort of in limbo, not knowing what they can do or not. So I'm not entirely sure, to be honest.
If we were minded to not approve this, could we make recommendations to the church as to what they should plant instead? I'm not sure you could put a condition on a removal of a TPO. Well, I don't know what we could do. Well, we'll leave our officer to ponder that. Are there any more questions? Councillor Laming.
Just to clarify things, what would you suggest that we replaced with?
What to replace them with? I mean, again, you could go with more limes if you want to continue the continuity of the area. Then you put more limes in there. I mean, that's what they've got at the moment, so there's no reason why they couldn't put a substantial replacement in. Not something that's a little skinny thing, but a fairly substantial tree in there that would, yeah, given the longevity, would be better than looking at those.
I think I saw something from.
What's tree size wise?
Members can use your microphones, please.
How many years old would a tree need to be substantial in terms of?
I don't. It goes on girth more than age, so you can get reasonable sized trees. The limitation you've got there is that footpath is very, very narrow. As you could see from the pictures earlier, you've got a very narrow footpath. So to get a huge tree in there would be almost impossible. So you could get something root balled with a fairly substantial root ball, which would be sort of 16, 18 centimetre diameter.
I think I saw something from a neighbour who was supporting to have the trees cut down, and they thought that they wanted to put in fruit trees on it. Anyway.
Yeah, I wouldn't.
No, I wouldn't recommend fruit trees.
Yeah.
Okay, Councillor Ashford.
Thank you. Are you, if the trees were to be pollarded, would that help, or are you suggesting that?
The problem you've got, that's not actually classed as pollarding. What's happened there, they've topped them. So pollarding is bringing all the branches in, so you actually get a branch structure to the tree, which would be great. But if you were to do any more to that tree, so bring it down to 3 or 4 meters, you end up with a big woody stump, which will end up with those tufty bits on top, which is what you've got here. And with the decay fungus you've got in there, it's probably likely to be further down the stem as well. So you'll end up with a huge stem that's going to decay because it never occludes, that will never heal over. And with these weak stems on the outside of it, so it will just end up being a 3 meter stump with a tuft on the top.
Councillor White.
So regarding the rot or the decay, what's the kind of lifespan of that? I mean, how much longer can that tree survive?
That's an unknown, to be honest with you. I mean, obviously that piece fell off during the process of us doing the notification. So it's going to continue to decay, but to what actual extent that extends down the stem, we know it's fully in the top because the piece is peeled out and it's fallen out. And the fungal bracket tells you that, but how far down the tree it extends is an unknown unless you start doing invasive drill testing. So it's a difficult one to call.
Councillor Langford Smith.
Thank you, Chair. Can you undertake resistor graft testing on living trees to establish the extent of the decay?
So you could do that. Yeah, that could be done. It's whether the church have got the money to do it, or whether they want to do it, is the honest answer. So it's not down to me to sort of, I can put that to them and say we can resistor graft it, but you'd be starting at the top because that's what the decay is, and then gradually trying to work your way down, which isn't sort of, I don't know if that's achievable, to be honest.
The reason for asking, Chair, is that would establish the existing life left in the tree and whether or not supplementary planting could take place in the meantime before this tree is eventually deceased.
Thank you for that clarification. Any more questions to our contributor? No? Thank you very much indeed. You may return to your seat. Thank you.
Thank you.
Okay. We have no other public speakers, so John, was there anything you wanted to add before we come to general questions?
Yeah, yes, if I can, please, Chair. So in terms of the suggested management going forward, we believe that these trees could be managed as a lower height pollard for at least sort of further 20 years, as shown with the trees that are here. So that they will still be able to contribute to the character and visual amenity of the location. These lime trees are actually characteristic of this particular area within the churchyard. So we believe they can be managed for that bit longer at a lower height to still carry on making that contribution to the local landscape. Obviously, new trees will take that bit longer to make that same contribution that these lime trees are making to the local landscape and the conservation area. Thank you.
Are we able to confirm this TPO, but with the proviso that pollarding as recommended by our tree officer would be allowed?
We couldn't do this on a particular TPO. We could only condition it if it was an application that was submitted. So without this TPO being confirmed, that those trees would be at risk of being felled because the TPO would no longer be valid.
So we need to confirm the TPO, and then the church would have to return with a request to do the low pollard.
Yeah, so we have indicated that would be an acceptable form of management in a future application.
Councillor Laming?
Is it possible then that we don't confirm the TPO but insist on replanting with a like for like basis or an additional tree as well?
No, I think we either approve the TPO or don't approve the TPO, and then it's up to the church what they do. Any more questions, members? No, so we move to debate. Councillor Laming.
Thank you, Chair. I find myself in a very unusual position here. But normally I would approve TPOs as they serve a very useful purpose within the community. Looking at these trees and listening to the expert, I'm in a quandary as whether it's worth doing a short-term measure when we should be looking at a much longer-term view of this from an ecology point of view, etc. So I'm not sure whether I can support this or not.
Councillor Williams.
Thank you, Chair. I do feel as though the amenity value is much less than sort of the normal sorts of trees that we see coming through. However, I still feel that with this being a conservation zone as well, I think applying the TPO would be a sensible decision to make today, and then a further application at a later date regarding the management of the trees themselves to increase their amenity value, or if felling is required, then a management plan to have full replanting or replanting alongside the management of these current ones in the future. But I mean, the application before us today is that we can't condition that, so I'd be minded to have the TPOs be put on so that in the future we would have some sort of control over the management of those trees, especially as it is in a conservation zone. And then conservation zones, we should only be accepting applications that conserve or enhance those zones, and removing the trees altogether today without any control over future management. I fear as though that either conservation or enhancing aspect would be ignored.
Councillor White.
Yeah, so I feel that the ecological and the community value of these trees as they are outweighs any problems that they might have at the moment. There doesn't seem to be a plan of what they might be replaced by, and it's very difficult to replace very mature trees with something equivalent of ecological value. So I would support it.
Councillor Langford Smith.
Thank you, Chair. I think I will support the officer's recommendation with the pollarding of the trees to come forward, possibly in a future application. It's also important to note that decaying wood provides an important habitat. So the church have the opportunity to mitigate the future loss of these trees through planting in the meantime. But for now, I will support the officer's recommendation of reaffirming the TPO.
So if there's no more, oh, Councillor Clear.
Just to say, I will support the TPO with the pollarding. I hope will take place in the future, but that is up to the church, I gather, to put the application, and fingers crossed, I hope they do it, but I support the TPO. Thank you.
Thank you. So I think that's all debates. So this application to confirm the TPO is before us. Can I see all those in favour of confirming this TPO, please?
That's 7, Chair.
And those against?
One, Chair.
And abstentions?
One, Chair.
So that's